Again, this is Maya Van Rossum. I'm the Delaware Riverkeeper and leader of the Delaware Riverkeeper Network. And, you know, we wanted to recognize that there are just so many battles, pipeline battles, that are taking place across the nation, with different organizations, each leading the fight in different areas. And as a result of all of these new battles, right, we've got new strategies that are being developed and advanced all the time. We've got new successes that are happening, or perhaps we have some losses, but from which we learn some really valuable lessons. And litigation, of course, is becoming a particularly important tool on the pipeline battlefront. And so we were really pleased to be able to put together and bring to you this webinar series. Tonight is the first one, so that we can bring forth the leaders who are advancing some of these most important strategies so that they can tell you firsthand about the experiences that they're having, the lessons they're learning, the successes they're having, so that we all can benefit from what they are learning in their efforts, so that we all can help one another, and so that ultimately we can all be more victorious together against these pipeline threats that are facing so many of us. With that, I'm going to turn it over to Bridget Brady from the Delaware Riverkeeper Network, who's going to go over a few housekeeping measures, and then we're going to jump right into it with our presenters. So thanks everybody again for joining us tonight. I hope you'll participate in the rest of the webinar series, because I think you're going to find it really incredibly helpful and valuable. So with that, Bridget.
Thanks, Maya. My name is Bridget Brady, and I'm Communications and Advocacy Coordinator at the Delaware Riverkeeper Network. So tonight's webinar is on the environmental review process for pipelines and other shale gas infrastructure projects that's required under the National Environmental Policy Act, or NEPA, and the litigation against FERC and pipeline companies who continually circumvent it. And tonight's presentations will be led by Schima of Save Our Environment, who's going to give us a little bit of background on NEPA and its significance in the pipeline review process. And then we're going to hear about 3 legal challenges involving NEPA violations from Stemplewicz of the Delaware Riverkeeper Network, Carolyn Elefant of the Law Office of Carolyn Elefant, and Margaret Shugart and Coyne Gibson of Big Bend Conservation Alliance. I think Maya did a great overview of the idea of the series. So, you know, we're going to be doing this series once a month. We'll be releasing a new webinar, and the next webinar after tonight is going to be on April 30th, and it's going to focus on the ongoing legal battles around climate change and FERC pipelines. And that one is going to feature Ellie Benson of the Sierra Club, Nicole Dillingham of Otsego 2000, and Aaron Stemplewicz of the Delaware Riverkeeper Network. So we'll be sending around links to sign up and register for that with the follow-up email. A little bit more info right there, sorry. And for now, too, you can just go to the bit.ly link up on that screen to get more info about the series and to sign up for all the ones that are ready to go. So we're still working on finalizing the dates and presenters for a lot of the rest of the series, but just to give you a sense of what's coming up, we plan on covering legal issues and cases involving pipelines and tribal and specially protected lands, environmental justice, other federal agencies and pipeline reviews, public need for pipelines, eminent domain, tolling orders, compressor stations in the Clean Air Act, the Clean Water Act and 401 water quality certification, the Clean Water Act and the National Pollutant Discharge Elimination System permits, as well as other state permitting. So I'm going to turn it over to Stephen in a moment to get started, but just a couple of really quick housekeeping points first. The webinar will be about an hour long, and we're going to try our best to honor that time period. We're going to have a question and answer session following Margaret and Coyne's presentation. So if you have a question that comes up at any point during the webinar, please just submit it through the text box as you think of it. And then I'm going to pose the questions to our presenters at the end for them to answer. We're not going to be opening up the phone lines for people to ask questions directly, so please just queue them up as they come to you during the presentations and type them in. And if we do have too many questions and run out of time before we get to all of them, we do apologize up front for that. And then finally, just a couple of quick related announcements and actions. We have an action alert that we're going to link to at the end of the webinar as well, directing people to call Congress and urge them to hold hearings to investigate the many ways that FERC abuses communities, its powers, and the law when reviewing and approving pipeline projects, and to also put in much needed reform. So if you're looking to take an action after the webinar, you can follow the bit.ly on the screen and plug in your information to get a call script, talking points, and be automatically connected with your representative in Congress by phone. And then second, the Voices Coalition, which stands for Victory Over Infrastructure Clean Energy Instead, is organizing an art installation and lobby days in Washington, D.C. on May 6th through 9th. And that's going to involve a big living sculpture on the National Mall right on Congress's doorsteps, and will be illustrating the harms done to our communities by pipelines and related infrastructure. So that's just going to be another great way to ask Congress to hold hearings and open investigations into FERC. And we're going to send out a link to the Facebook event and more info in the follow-up email as well. And then finally, stopthepipelines.org is just another great resource for communities across the country who are facing frac gas infrastructure projects to share information, tools, and resources with each other. So check out stopthepipelines.org. And we're going to be sending out all of these links, as I said, in a follow-up email. We're also hoping to have a recording ready soon that we'll include in that as well. And so with that, I'm going to turn it over to Stephen.
Thanks, Bridget. And I'm just going to advance a slide here. So as Bridget mentioned, I'm the director of the NEPA campaign. I'm with the Partnership Project. The Partnership is a network of about 20 national environmental organizations. I just work on NEPA issues, and for the last several years, it's primarily been NEPA defense, because we're going to talk about the law today, but there's real sustained and aggressive effort underway for the last decade almost, trying to undermine this law, trying to undermine its core requirements. We also do educational workshops around the country, but the vast majority of the time is working on legislation and administrative actions related to NEPA. I'm just going to give a real thumbnail sketch of the law and how it works, and then let our other presenters kind of dig into the details, especially with regard to the litigation. But there are some resources out there that I want to flag. I mean, I would assume that some of the folks on the call have a little bit of experience with NEPA, or maybe even more, but for those that are just getting acquainted with the law, there's a Citizen's Guide to NEPA that's available on nepa.gov. That's the Council on Environmental Quality's website. It's actually a really helpful document. It's also available in Spanish for the first time, which brings in another 40 million Spanish-speaking folks in the country to be able to get involved in the process. There's also a really good article I wanted to flag that is useful for the pipeline discussion, especially like greenhouse gas consideration, and that's by Jessica Wentz and Michael Berger at Columbia Climate Law Institute, where they actually have a litigation tracker that's also useful. And then there's our website, which is protectnepa.org. We have some basics of NEPA. We also have success stories from around the country with an interactive map you can use, and there's also different ways to get involved. But for now, I just wanted to go through the basics. And NEPA, the National Environmental Policy Act, is what the name implies. It's a statement of our national environmental policy. It was passed in 1969 and signed into law by that great environmentalist, Richard Nixon. It is one of the most widely imitated laws the U.S. has ever created. There's 160 countries that have adopted similar legislation for a simple reason, and that is the law enshrines 3 values into all federal decisions. And I should actually have added a 4th here, which I'll get to. But first and foremost, it requires environmental review. It incorporates environmental values into federal decisions. And the environmental impacts that it requires review of, you should think broadly of this. It's the human environment. And that includes social impacts, cultural impacts, economic impacts, and other health impacts. So it requires the government to study these impacts, but it's also a sunshine law, and it requires the disclosure of those impacts to the public. This is something that we all rely on to find out what these projects are doing in our communities. Critically, it's not just disclosure, but the government's required, agencies are required to solicit public input. They have to provide an opportunity for meaningful public input. And with environmental impact statements, which I'll talk about in a second, there's multiple opportunities to weigh in. And then fourth, which is not listed here, but is critical, especially for today's discussion, is accountability. NEPA demands a process. It requires the government to go through a process before approving projects or issuing permits. But it also allows citizens to hold the government accountable if they don't follow that process. And that is something that is increasingly under scrutiny right now, and I'll talk about in a minute. But those are the four values. It's environmental review, disclosure, public input, and accountability. When you think about environmental review, there's three types. And I'm going to just talk about these briefly, but it's not a subject today, but people should be aware of categorical exclusions. These aren't waivers of environmental review. They're actually one form of environmental review. They're classes of actions that agencies have looked at so many times, they're routine, and they know that there's not going to be a significant impact. So they're often used in legislation as a type of waiver, but in reality, they should just be one form of review. The next level of review is an environmental assessment. This is where an agency isn't sure what the impacts are going to be, so they do a preliminary study. This is supposed to be concise. They often run long, but they are meant to determine whether or not an action may have a significant impact, and then whether or not an EIS is required. If the agency determines there is no significant impact, they issue a FONSI, or a finding of no significant impact. However, what people are most familiar with, and this is, the organizing opportunity for, especially for getting involved in pipelines, is the environmental impact statement. And this is the full-scale review that's required for the actions having that significant impact on the quality of the human environment. And this is where agencies are required to, issue a notice that they're going to consider this project. They have to go through a scoping process. They have to consider all reasonable alternatives to the project, ways to achieve a certain end, but different means of doing that. So EISs are often what folks are involved in, but environmental assessments as well. With regard to pipelines, the agency that we most often have to deal with is FERC, and that's the Federal Energy Regulatory Commission. They have the authority over the construction and operation of these pipelines, as well as LNG export terminals and the associated infrastructure. And it's during this environmental review process, whether it's an EA or an EIS, that we run into this problem that's the subject for today, which is segmentation. And the issue here is essentially we're looking at ways that companies or agencies can avoid a full environmental review. And the issue here is, has the agency wrongly separated the review from other related actions? Are they narrowing the focus? And should these actions be considered together? There's related questions oftentimes of, is an EIS required, and or what form of analysis is needed? An issue sometimes is, are there federal and non-federal projects which are so closely related that they should be considered a federal action? There's a rule against segmentation. I put rule in quotes because this comes up case law, but I think this isn't one of the cases we'll talk about today, but courts have said that, the rule against segmentation is that, prevents agencies from dividing a project into multiple smaller actions, of which individually has insignificant impacts, but collectively have a substantial impact. And the idea here is that agencies can segment a project to evade closer scrutiny. And when the regulations were drafted, the CEQ regulations, and when I say CEQ, that's the Council on Environmental Quality, they issue the regulations for NEPA that are applicable to every federal agency. And every federal agency has their own implementing regulations, but CEQ regulations provide the floor that agencies must abide by. And CEQ had several regulations related to this, and I list them here, and I'm not going to read them to you, but I'd like to draw attention to them so that there is a resource. But it is discussed in several parts of the regs. Now, the regulations are something else that I'd like to discuss, because this is an area, we're talking about how the companies or agencies, can avoid environmental review. And, we'll focus on the litigation mostly today, but there's also something else to be aware of here, and that is that there are other attacks going on right now that are relevant to pipelines. And we saw this at the beginning of this administration. President Trump said at the beginning of the administration, generally speaking, we'll be giving you your permits. So there's this ethos right now that projects should move faster, the permitting should move faster with the eye towards approval. There's putting a heavy thumb on approval. And we've seen this borne out over the last couple of years. We've seen a number of legislative and administrative actions across government. A number of agencies are reviewing their NEPA regulations with an eye towards, quote unquote, streamlining them, which is a euphemism that's often employed that in actuality is an effort to roll back public input and consideration of impacts that these are the core values of NEPA. Right now, what we expect are something to happen in the infrastructure space, which includes pipelines. Right now, there's talk of a big infrastructure package in Congress. Whether or not that materializes, we certainly expect to see discrete pieces of legislation offered up, and I will talk about a few of those in a second here. But there's two other things that are going on right now that I think are worth drawing attention to, because I think folks may want to get involved because it'll impact how we can get involved on these pipeline pipes. And one is a revision of the regulations I was just talking about. The CEQ regulations have been in place for over 40 years. And those regulations, like I said, are the basis for every other federal agency. The White House is now in the process of revising those, and they went through an initial stage, which is called an advance notice of proposed rulemaking, and that was last summer. And right now we're waiting for the actual notice for the proposed rule to come out. And they are considering everything, and that includes what we'll be discussing today. The entire set of regulations are open to revision at this point, and we fully expect that this will impact things like the consideration of climate impacts or indirect impacts or cumulative impacts, which we'll discuss maybe a little today. But this is the existential threat right now to our ability to get involved in federal decision making. These are going to strike potentially at the core of all of the things we just discussed, which are environmental review, public input, and accountability of litigation. The CEQ is also looking at revising a climate guidance, and this is kind of a preview of next week, but it's worth flagging now because it's going to come out soon. One of the first things after President Trump said that in general we'll be giving you your permits was the first action was to revoke the President Obama's guidance on how federal agencies should consider climate change in their decisions, and that's under NEPA. So this was a guidance for showing agencies how to consider not only the impacts of a project on climate change, but also the impact of climate change on projects. We fully expect that this new guidance won't be nearly as robust, that they will try to limit some of these considerations. This will be hopefully an opportunity for the public to weigh in and say exactly how we want these things considered in projects like pipelines. But there's also legislation. And this bill here is just one example of legislation that has been introduced, that we expect will be introduced again in this Congress. It's been introduced the last three. We've seen it for the last 6 years. It's called the Promoting Cross-Border Energy Infrastructure Act. This bill would limit the scope of environmental review essentially to a very narrow slice for cross-border pipelines, essentially, the few feet where the pipeline's actually crossing. And it forecloses any consideration of upstream or downstream impacts and cumulative impacts and things of that nature. This bill has been brought up in both the House and Senate, so it is the kind of bill that we'll see in the pipeline context. But there's also another bill that actually passed that is a way for companies and agencies to evade the kind of scrutiny we want them to be giving these pipelines, and that was a bill called the FAST Act. It was an infrastructure bill that passed in the last Congress, and it applies to any project over $200 million, including pipelines. And what that bill did was limit the consideration of alternatives, which I just mentioned. And that's a really important part. It's the heart of the NEPA process, but it also limited judicial review for these types of projects. And that is currently law, but it's also up for reauthorization soon. So these are the types of threats that we're seeing in the administrative and legislative space. But as it is now, we still have the law, and that accountability is there, and there's an opportunity to hold agencies accountable. NEPA never requires agency to choose the most environmentally friendly outcome, but it does require them to go through this process, which has been the subject of litigation, and I will turn it over to my colleagues here, but I do want to add, and we'll have some more resources at the end, but if you want to find out more information about the rulemaking of the CEQ regs or the climate guidance or anything else, you can visit the website protectnepa.org. There's also the Delaware Riverkeepers Network action page, and there's a petition and there's updates, but we can highlight those again later. So I'll turn it over to my colleagues now.
Thanks, Stephen. That was a great primer for what we're going to get into and maybe a little more into the weeds in the next couple of presentations. My name is Stemplewicz. I'm the senior attorney at the Delaware Riverkeeper Network. And I'm going to really focus most of my time today on a case that we brought back in 2013 and 2014, got the decision in June of 2014. And it was essentially the very first case in the history of the Federal Energy Regulatory Commission where they lost on NEPA grounds, at least that we're aware of. There might be another one out there, but I'm not aware of it. And so I want to give a little bit of the background of that case, how we became successful, and also I want to talk about the implications of that decision, and specifically I want to talk about, I mean, you can read the case for yourself, but I want to give you my take on it. Every time I read this opinion, I end up taking something a little different from it. So I'm going to give you my 2 cents on what its implications are and what it means moving forward. I'm also going to really briefly touch on a case that we brought as sort of a corollary to this case that was recently decided in December of this year, where we weren't successful, and hopefully I can impart some helpful knowledge on some lessons learned in that case. Fortunately, it's unpublished. Okay, so to get back to our initial case, Delaware Riverkeeper Network case, we began thinking about ways to challenge a series of pipeline projects back in 2013. And we realized that there had been successful NEPA litigation in the past employing this segmentation theory only in the context of other types of linear infrastructure, such as highways or other public transit like trains or subways, things of that nature. And we thought that we could take this concept of segmentation and use it in the context of pipelines. And again, no one had ever done this before. We thought, and I'll quickly go over one quick question. Is an unpublished decision just means it's non-presidential? It's an opinion issued by a court that is essentially usually much shorter in length. It gives an idea of what the court and what the judges were thinking, but it's not presidential in any ways. In other words, it's not controlling moving forwards. So just wanted to make that clear. So to get back to our case, essentially, if you read the case, you realize that there are essentially 2 different standards for segmentation that the court identifies. And the first is the CEQ standard, what I call the CEQ standard, and the second standard is the taxpayer's watchdog standard. And if you read the case really carefully, you'll realize some interesting things with regard to the CEQ standard that the court really relies on. And the first part of the opinion, the court cites to 40 CFR 1508-25, and it applies the analysis required by 40 CFR 1508-25 to the environmental review of the Northeast Upgrade Project, which is the project we were challenging. And the most interesting part of that is that if you read the opening section of that regulation, you see that it states, and I quote, "Scope consists of the range of actions, alternatives, and impacts to be considered in an environmental impact statement," right, an EIS. So as Stephen was discussing earlier, there are three types of NEPA review. There's categorical exclusions, environmental assessments, and environmental impact statements. I am unaware of a situation in the past where the court has specifically applied 40 CFR 1508.25 to environmental assessments. This was the first time that was done. It was big. It was an issue we were a little concerned about in our briefing, but we were able to convince the court that yes, that is the appropriate analysis here in context of segmentation. And that was a really, really important win. I mean, you look at overall what that means, you look at overall what this case means, and it is important for segmentation, but it was really important for this really small specific point of law. So now, not only for EISs is segmentation a really viable legal theory that has some teeth, but it's also a viable legal theory with regard to federal actions where an EA is issued instead of an EIS. So that's something that's a really important takeaway from this case. And the court really admonished FERC for never even citing to these regulations in their defense of their actions. And the court goes out and says, explicitly states, an agency's consideration, quote, of the proper scope of its NEPA analysis should be guided by the governing regulations. And the court goes on to say, the agency's determination of the proper scope of its environmental review must train on the governing regulations, which here means 40 CFR 1508.25a. And so from the way I read this case, frankly, the court should have stopped right there because that was all that was necessary for the court to decide in our favor. And frankly, the rest of this decision, in my opinion, can be understood as dicta. I'm not so sure that that's the way it's been interpreted since this opinion has been issued, and I think that's unfortunate because I think it's been some sloppy reading on the part of some judges' clerks and even some of the attorneys defending the agency action, really twisting what the standard here is. So to the extent litigation is right, really, if you're going to bring litigation based on segmentation, focus on 40 CFR 1508.25. That's really the key. And make a point to say that the rest of that technically is dicta. The court went on to go in particular detail about another standard, the second standard that I referenced earlier, called the Taxpayers Watchdog Standard. And that standard is derived from a case that was not a pipeline case. And the court even indicated in its opinion saying that even on FERC's own terms, and FERC used the Taxpayers Watchdog Standard in their defense. And the court said even if that were the standard, they still lose, and then went on to explain why. And I'm not really sure why the court did it other than to cover for in case this got appealed to the Supreme Court, making sure that they really nailed all of the potential avenues for overturning it, nailed it down. That being said, I think it's resulted in some confusion about which standard applies. So again, I would turn you to the Taxpayers Watchdog, the analysis in the opinion of the Taxpayers Watchdog case. The court really focused on logical termini and substantial independent utility in its analysis, looking at how the project, the four projects that we alleged were in fact connected, were not connected. And I'm just going to move actually to this slide here. This slide here actually shows, provides a depiction of the different projects that were linked together and sort of leapfrogged each other to create the four pipeline projects to create a single continuous pipeline. And that's really what the court bought into. This idea that there is a functionally interdependent, single, continuously uninterrupted pipeline from the middle of Pennsylvania all the way into New Jersey. And the court really sort of glommed on to that idea, and in addition to the timing. And the court also noticed that the timing was overlap substantially. And as you can see from this quick representation of the way in which the projects sort of overlapped when they were being considered by the agency. So I think if you're going to bring litigation, again, I'd say focus on the governing regulations and finding ways to argue that your projects that you think are being segmented in their review are similar, or are connected, or are cumulative in their capacity. And one other important point there, and I forgot to mention this earlier, is to the extent, so those are the three ways that you prove segmentation in, according to the governing regulations. Connected actions, similar actions, cumulative actions. If you look closely at the regulations at 1508.25, you'll see that the similar actions analysis, there's an argument that it can be discretionary. But in the opinion, in the D.C. Circuit Court's opinion, they require that analysis to be done. It's non-discretionary. So I think it's still up in the air. If you can show the two actions are similar, and to do that, really you only need to show the actions have similar timing. I think it's really an open question that is going to be need to be resolved in the future. But looking at the regulations, I think there's an argument that it can go both ways. Fortunately, we have some good case law backing up the way in which we would interpret it, which is that similar actions must be included in the same environmental assessment. I'm going to conclude now just by discussing our corollary case. Now, in our initial case, there were 4 pipeline projects, 1 continuous pipeline that went from middle part of the state to New Jersey. Tennessee, a couple of years later, started adding new looping projects, creating a 3rd pipeline that essentially paralleled the pipeline that we had fought over in this case. And again, doing the same thing where they're creating little loops. And so we brought litigation after 3 of the projects had been completed. And we argued that, again, this is clearly segmentation. Tennessee Gas Pipeline Company even calls all the pipelines the same thing. They call them the 300-3 line. And we argued to the court, okay, D.C. Circuit, the only difference between this case and the previous case that we were successful on is that we caught them earlier in the game. And a 3rd continuous pipeline wasn't yet completed, but we're just catching them earlier in the act. And the entire purpose of NEPA is informed decision making. And right now, we know they've done it in the past. We know what it looks like. We want to try to catch them earlier now. So we brought that action, trying to sort of push and expand the sort of segmentation analysis. And we thought this was a great corollary case to bring. The facts were right. We had passed over a bunch of cases where we could have brought segmentation, but we didn't feel like the facts were strong enough. But the court ended up rejecting this analysis in their opinion. In fact, the opinion that they issued in that case had literally 1 sentence devoted to segmentation, probably because they didn't exactly know how to deal with it. At least that's what I think. But it's a lesson learned that, at least in this context, the court wasn't quite ready to jump ahead and say, okay, you don't have a continuous pipeline. You don't have this function. You don't have this continuous pipeline going across parallel to these other 2. We're not ready to call that impermissibly segmented yet. And really, when we brought our case, we sort of relied on the lack of information. In other words, we argued that there is nothing in the record indicating that any one of these 3 new projects could operate independently of the others. And I think what the court wanted to see was affirmative information showing that they absolutely could not operate without one another, rather than FERC not doing the analysis to show that they could operate independently. So perhaps that was a lesson learned, that maybe we needed to really dig down and find a way to prove that and establish that in the record. Because I think that was a real powerful piece in the previous case where we were able to show that. So with that, I'm gonna conclude and hand it over. And to the extent you have any questions about these two cases or segmentation, I'm happy to take questions at the end. Thanks.
Hi, it's Carolyn Elefant, and I am here to talk about the City of Boston versus FERC case. This is a segmentation style case where we relied very heavily on both the regulations but also the precedent in Delaware Riverkeeper, and I have some thoughts on the scope of that precedent. In my own personal litigation, in the cases that I litigate, I do not plan to bring any segmentation cases in the future unless there's something that is so starkly obvious. I mean, like, plans all over the place saying segmentation and, pipelines that were clearly split. I just think that the court is retreating on the position that it took in Delaware Riverkeeper back in 2014, and I don't hold out much hope for advancing those particular arguments in an appellate context. But I'll talk about that a little bit after. Let me just get to the facts here. So, City of Boston case, it was actually two parts. There were two petitioners in the case. The lead name is City of Boston. They were not involved at all in the segmentation issues, and their claims, unfortunately, were disposed of on procedural grounds. I represented a group of opponents to the Algonquin Incremental Market Project. There's the regular Riverkeeper group named SAPE, some other groups that had all been formed to oppose this project. And really the biggest concern about AIM and what I saw as the biggest problem was that this was going to substantially expand a pipeline that ran within a few hundred feet of a large nuclear facility. So the primary concern of most of the people in the area was safety, but obviously we looked at other ways to challenge the project. And one of the ways that was proposed, as you can see from the map, is there were basically three stages to this project. There was the AIM project on the left. You can see the path of it. The Atlantic Bridge project is in the center, and over there, if you look on the middle map with the Atlantic Bridge, that yellow line shows where the AIM project is, and then the middle is Atlantic Bridge, and the last one is actually going up to Access Northeast, which you also see on the right. So this was basically going to expand the Spectra's pipeline highway from the Mid-Atlantic all the way up through Canada. And so the way it was proposed was in different pieces. In the AIM piece, there was going to be some pipeline expansion, the addition of some compression. It's got the different pieces. This basically describes what each piece of the project was. So AIM was going to have a new 42-piece segment and then some compression. Atlantic Bridge, one of the main features was a compressor station in the town of Weymouth and also other compression upgrades along the route and maybe some metering stations, I think. And then the Northeast Connector was ultimately supposed to go all the way up to Canada. And the way that these had been proposed was in a very sequential order. On this slide here, we had done sort of a timeline of all of the different projects. And you can see, the extent of the overlap. You see, like, the AIM project started in 2014, and then, each time a piece of it was finished, another one would come up on its heels. And so, so it looks like from the timeline that, this was a project that was segmented. We also had found, we'd had an expert who showed that the way that the AIM project was being built was to basically leave the door open to connect to the Atlantic Bridge project. And so, we had that evidence. And there were also parts of there were shippers who had contracts on both the AIM project and the Atlantic Bridge project. And there's even one part of the project where some unfortunate landowner had two FERC projects being built on his property at the same time. They were that close. They were within like 10 or 15 feet. You think it was an obvious segmentation case. But there were a couple of things that happened along the way between the FERC proceeding and the court case. The first was in some ways it was a victory because a group of opponents had challenged these pipelines in the state rate proceedings because these projects were going to ship gas to electric power facilities in the New England ISO, and in Massachusetts and in other parts of New England, there you have retail competition, and so electric providers can't lock into long-term contracts with gas companies, and essentially that's what they had done here, and so the contracts were vacated. So without the contracts to support the project, Northeast Connector was put on hold, and so that was put on hold before we went to the court, and so part of our FERC case, which consisted of showing these 3 segments, we already had that piece lopped off. Now, again, that was a positive because the project wasn't going forward, but it was a negative in terms of being able to make the segmentation case. Another thing that had happened was during I think the pre-filing consultation for Atlantic Bridge, the Atlantic Bridge wound up getting downsized in part because Northeast Connector was gone, and in part because some of Atlantic Bridge was kind of swallowed up in the Algonquin Incremental Market project. And the third thing is that the AIM project was actually the subject of an EIS because it was going within a few hundred feet of a large nuclear reactor, so FERC thought to do an environmental impact statement, and all of its wisdom making the right decision one time. So those were some of the problems with the case, and so it didn't come as a complete surprise when we got to court that the ultimate holding was that there was no segmentation. And essentially what the court looked at was, first of all, it found that the projects didn't depend on each other to bring gas to market. And to some extent that's true. I mean, when you're adding compression, it's very different from when you're adding sort of a linear piece to the project. And I think that that's part of the problem, is that a lot of what was segmented was the Atlantic Bridge project, which was a compressor station. And it was segmented from this earlier piece. Now, this is the second thing. The court also found there was no temporal overlap. And so, like I said, over here, you saw the overlap. But what happened is, pipeline companies aren't stupid. So when they see a court ruling that says, hey, temporal overlap is one of the features of segmentation, well, guess what they decide to do? They decide to space the projects out a little bit longer. And so you have a 3-month gap instead of a month overlap or something. And so that was one of the things that had happened here. Like I said, the Northeast project was postponed for positive reasons, but the Atlantic Bridge project, we believe, was held up, whether intentionally or not. The fact of the matter was that it was held up beyond what it was supposed to be, and so things were stretched out a little more. Again, the other factors I think the court took into account is, first of all, when the AIM project was being reviewed and Atlantic Bridge was in pre-filing, the Atlantic Bridge project wound up getting downsized. And, at the oral argument, one of the judges asked me, what's the point of these segmentation cases? Why do you care how they're reviewed? And my response was, well, if all of the cases are reviewed all at once, the agency has an opportunity to potentially eliminate parts of it if it can view them all as a whole. So, it not only does viewing them as a whole avoid overlooking impacts, but it also gives the agency an opportunity to take a more holistic approach, and you may wind up with a smaller project than you otherwise would. Well, essentially that's what had happened in this case, only it happened during the pre-filing process, and it didn't reduce the project as much as my clients would have liked. And then the other thing is, like I said, unlike Delaware Riverkeeper, City of Boston was a mixture of compressor and pipe, and I think that makes segmentation hard to prove. And that's a theory of mine that's borne out in subsequent cases too. In Minisync, we had tried a segmentation claim. There had been, we had seen the pipeline's plans to build one compressor at one site, second compressor 60 miles down the line very shortly thereafter, and then build out a piece of pipe that was found to be not segmentation. They were way too far apart. Bordentown versus FERC, that was a compressor that it was being built right off Penn East to get gas from Penn East to a New Jersey segment of the pipeline. But again, because it was a compressor station, I think the court found that, the court agreed with FERC that it was just completely independent and it could just be used to moderate the compression on the Trans-Pecos main line, even though it wasn't to just moderate compression on the main line and be used as independent, even if this New Jersey piece wasn't built in. So, so these are sort of disappointing results. And, like I said, these are my takeaways from the segmentation cases. First of all, now that the case law is clear, companies can work around it and they can plan around it. And that's what we've seen. I've seen cases that, companies filing things like if you look at the Mountain Valley case, Mountain Valley Pipeline was approved and a few months later, I guess an offshoot piece was proposed. I think before these segmentation cases, the pipeline would have been much more brazen and, filed for that offshoot like right on the heels of the Mountain Valley Pipeline case. Now it waits some time before filing it because companies are aware of that that's one of the criteria. And then I think also, to some extent, I think some of this is one area where raising segmentation has in many ways been a success because I think in some ways, companies are putting off development, but I think in other cases, like you see here with AIM and Atlantic Bridge, you do see something where you did have a downsizing of the project. And the last thing is I feel like even if you don't have segmentation in your arsenal of weapons, it doesn't preclude project opponents from asking for a comprehensive review of the project. I mean, granted, FERC does not always understand the meaning of the term cumulative impacts, but cumulative impacts was another aspect, sort of the stepsister of the segmentation review. And so even if you can't ask for segmentation outright, you can still ask FERC to evaluate the cumulative impacts of having all of this development taking place in a similar area. I think that is in many ways, I think it's an easier push. You don't need to show that there's necessarily an interdependence between the projects. You just need to show that, the next leg of the project is imminent. And I think it allows you to focus on, what's really at the heart of these cases, which is avoiding these types of cumulative impacts or, overlapping impacts. But, like I said, I mean, Delaware, I have to commend Delaware Riverkeeper because Aaron's right. I mean, he was correct to characterize the case that way as a huge, a tremendous, tremendous victory. And I don't know if it's one that FERC, I think, was completely surprised about. But at least, like I said, with the cases that I'm handling moving forward, I don't see myself raising a segmentation case claims. I just don't think that, I think there are very, very few that are winnable. And the other thing that I've noticed at the DC Circuit is there is definitely a strong air of pipeline fatigue. And I think that the court is starting to get very tired of, kind of hearing the same arguments raised again and again, and or a lot of arguments raised all at once. And I personally, my own view is that the DC Circuit is treading on violating due process rights of people to bring challenges and have meaningful review of FERC cases. But be that as it may, if the case winds up in the DC Circuit, I'm not going to have, I'm not going to pursue arguments that I don't think can win. And again, this is my own personal view. I think segmentation cases are really a difficult stretch these days, at least the DC Circuit. Maybe worth trying at a different circuit. And like I said, definitely worth raising in the underlying process because it can create some opportunities for you to get some victories, not at a court, but before FERC through project modification or, putting a project off. So anyway, I'm happy to answer questions afterwards. And thank you for inviting me to speak.
Hi, this is Margaret Shugart with the Big Bend Conservation Alliance, and I am here with Coyne Gibson as well. And we are going to talk about a case that we also brought against FERC that was partially related to NEPA review, but also related to 3 other statutes. The pipeline at hand was a 148-mile pipeline, 42 inches, and high pressure gas. It was interesting at the beginning to hear about the bill HR 2883 because this is essentially the sort of project that it would allow and the kind of permitting that it would allow. So I'm not even sure that they need to pass that law at this point to do that. But the Trans-Pecos Pipeline was one continuous project, and it started at a point near the Waha Market Hub in the north, and we have a little map for that, and ended at a midpoint in the Rio Grande River. There was no other gas pipeline except for the Trans-Pecos Pipeline that fed that Presidio border crossing at the river. And in the application, their application to FERC, they explicitly stated that they plan to move interstate gas after moving intrastate gas, so just gas from Texas for an unknown period of time through the pipe. That unknown period of time ended up being only 5 months. And the Federal Energy Regulatory Commission approved this pipeline as 2 separate segments. One, which was the section from the middle of the river essentially to the shore, was only 1,093 feet, and the rest of the 148 miles was seen as a separate project. The portion, the 193-foot section, was regulated by FERC, and the rest of it was left to the Texas Railroad Commission, which performs no meaningful environmental reviews.
So this is Coyne Gibson. I'm going to talk briefly to the schematic slide. The project as conceived consisted of a header portion and head-in compression station at the Waha Market Hub that appears to the left of the slide. The initial conditions were that there were 5 interstate pipelines and 7 intrastate pipelines connected to the header, along with a connection from pooled underground storage. The segment that is considered non-jurisdictional is the intrastate segment, which is nominally 148 miles long, extending from the Waha Market Hub south-southwest to the border crossing. And then the jurisdictional facility, which you see to the right, started at a defined custody transfer and metering station and extended for 1,093 feet from the custody transfer station to the center of the Rio Grande River, which defines the border with the United States and Mexico. The FERC, the owner-operator of the pipeline, and ultimately the DC Circuit bought into the legal fiction that 1,093 feet of pipeline from essentially the shore to the center of the river had standalone functionality and was not dependent upon either the upstream or the downstream pipeline connections from the north or south into Mexico.
And this is a map, Waha at the top and the bottom being the crossing at the Rio Grande. The region that it runs through is a rather pristine high desert mountain region called the Big Bend. And there were a lot of aspects at stake that a full EIS or even a proper EA would have unearthed and shown. Part of it is habitat for several unique species. There's also an unknown number of archaeological artifacts and historical sites because the property is primarily privately owned. The picture here is of an area called Trap Springs that was a mix of Native American and colonial settlers artifacts, and these are cooking mittens. The entire area was destroyed by Energy Transfer Partners as we were attempting to have it listed on National Historic Registration. They stopped work at a different part in the pipeline and brought their machinery down and destroyed the archaeological evidence. There are also several ecosystems that were recognized in a binational agreement between Mexico and the United States. There were 133 named and unnamed separate stream crossings, and the pipeline also went through a town called Alpine. So the case is a little bit complicated. We've covered the national policy, or well, we've covered NEPA, so we can skip through this slide, but setting up the stage for segmentation. And, oh dear, sorry. There are also two portions of the Natural Gas Act that we brought into the case here. The first is Section 3. Section 3 essentially governs export facilities and says that FERC has jurisdiction over them. The Natural Gas Act, Section 7, says that interstate pipelines are also under the jurisdiction of FERC. And then Section 311 under the Natural Gas Policy Act is a little loophole that was meant to be applied in a very narrow sense. And it says that if there is an intrastate, so moving gas within the state, pipeline in place, an interstate pipeline may use that existing facility to move interstate gas without it coming underneath FERC jurisdiction. So the issues that we raised in the case are first under Section 3, whether FERC's jurisdiction of the Trans-Pecos Pipeline was limited only to that border area of 1,093 feet, or if the entire pipeline was actually the export facility, since all of it was built and intended only to export gas to Mexico. The second issue was whether the 148 miles of the Trans-Pecos Pipeline that was not under FERC jurisdiction could be considered intrastate and thus avoid environmental oversight if its initial for unspecified time, which again was only 5 months, function was to transport gas only sourced in Texas, but its original application stated explicitly that it intended to move gas sourced from multiple states, and also if there were no contracts or customers for intrastate gas, which was the case. And an intrastate pipeline should, during the application, and Coyne, correct me if I'm wrong, there should be at least 3 contracts for customers within the state, and there were 0 at the time of their filing. And then lastly, the issue of impermissible segmentation. In this case, it was federalizing. So looking at whether the 193 feet of pipe near the border and the other 148 miles of the pipeline were indeed 2 separate systems, one requiring federal oversight and one only under the state, or whether they were one interdependent connected line that was impermissibly segmented to avoid oversight. Our arguments for these issues were, first, that Trans-Pecos Pipeline should be regulated under Section 3 because the entire pipeline was the export project. Under the second issue, we argued that if not under 3, then certainly under 7, because the intent of the pipeline is to move interstate gas, and that it only moved intrastate gas for 5 months and had no customers for that gas in its original application. It has 1 customer now. And even if the entire pipeline were not subject to FERC's direct regulatory authority, that it should be subject to NEPA review because it is a connected, cumulative, and I'm forgetting the other one, action. So the court's opinion, the court did recognize that Trans-Pecos Pipeline's application under Section 3 was to build an interstate pipeline, and the application for the interstate pipeline were simultaneous, so there wasn't even the separation that Carolyn was talking about temporally in her discussion. And even though the Trans-Pecos Pipeline's application stated that it intended to move interstate gas, and it was determined in oral argument that it had only done so for 5 months before moving to interstate gas, that this pipeline would connect with other intrastate pipelines and might later connect with interstate pipelines, even though it had already done so. In response to our arguments, they said that we did not sufficiently raise the first regarding Section 3 in our docket, even though we had several points at which we discussed Section 3 and how FERC had incorrectly isolated a portion of the project to avoid jurisdiction. The court said that it wasn't enough and that our arguments were couched too closely to our Section 7 and our NEPA review arguments. For our second argument, the court said that it is permissible for a pipeline to use, you remember that last statute, Section 311, for the construction of new pipelines that initially transport interstate gas, even if there's no set time before the pipeline begins transporting interstate gas, and even if the pipeline might artificially construe its purpose as an intrastate pipeline to avoid FERC jurisdiction. So the court said that it could imagine that possibility, but that wasn't the case here. 5 months was sufficient, and that FERC has asserted Section 7 jurisdiction in other similar cases, and FERC indicated that it might have asserted its Section 7 jurisdiction here if it had detected an effort to evade the Natural Gas Act, but FERC surprisingly did not detect that. And under segmentation, they said that although the pipeline was undoubtedly a single physically, functionally, and financially connected project, the point was that the bulk of it was not the subject of federal jurisdiction. So this is something that Coyne likes to say is the snake eating its tail. Since they did not regulate all of the pipeline, then they couldn't regulate all of the pipeline. So they said that connected actions don't dictate that NEPA review encompasses private activity. And they said that Delaware Riverkeeper, the 2014 case, doesn't apply because all the segments in that case were under federal jurisdiction. So the holding was that they denied our petition for review. And just to share some impacts to date, as of February 22nd this year, the pipeline has not moved a single cubic foot of gas to Mexico. It has provided a little bit of gas for a new chili roasting plant that was sort of a dummy project along with this pipeline. There have been 6 reported emission events, 3 have been maintenance blowdowns, and 3 were unplanned. And the emissions have totaled about 8.7 million pounds of greenhouse gases, mostly methane. We also included in our slides how to fight back, and that was something we discussed with the group earlier. So our advice was to be sure to build your docket and to involve the community in doing so. And that's our presentation.
Thanks. I think that was a great useful presentation. This is Aaron again. I just want to jump in and sort of wrap things up here. And I just wanted to push back a little bit and with what Caroline had said about the use of segmentation and how viable it is as a legal theory moving forward. And while I definitely agree with her that the DC Circuit certainly has pushed back a little bit or more clearly defined how segmentation claims will be viewed since 2014, I think one important thing to keep in mind is that if you want to bring a segmentation case, it can't be done haphazardly. It has to be, you have to laser focus on the regs, and as was just alluded to, you really have to build a really strong record. And to do that sometimes requires spending some money. For example, to prove segmentation, a lot of times you have to prove the interdependence of projects, that the projects are interdependent parts of a larger action that depend on a larger action for their justification, right? And how do you do that in the context of pipelines? Well, one way to do it is to get access to, for example, the flow diagrams that are provided by the pipeline companies to FERC, which can be tricky because they're often submitted pursuant to CEII, or they're privileged in some capacity, so they don't appear right on the FERC docket. So you really got to jump through a few hoops to get them. You can get them. FERC regularly gives them out. Sometimes you need to sign non-disclosure agreements or things of that nature, but you can get them. And then the key is to have someone competent to interpret those to show how the actions are connected, right? And that really is the key piece I think moving forward, to the extent you're bringing segmentation claim, yeah, you can do it. I mean, there are, just as was shown in this last presentation, there are projects that are physically, functionally, and financially tied together. It just so happened that in that case, the court didn't find sufficient, them to be sufficiently federalized actions. But there are facts out there where I think this theory definitely still is viable. We just have to be careful about which cases we as a group, as a community, as lawyers, choose to proceed using this type of legal theory. But I would think that it's certainly still viable as long as it's done, again, with laser focus and using the right mechanisms to do so. I'm happy to answer any other questions along with the other presenters to the extent you have them. I don't know if we've had any specific ones to this point.
Yeah, so we have a couple minutes left. We're coming up right on the end of our time for the series, but if anyone wants to put in a question quickly now, I'm sure we can squeeze it in. We've gotten one question that is not really necessarily along the lines of segmentation, and I just want to note it is going to be something that's probably going to be covered in one of the future webinars, but if anyone wants to speak to it at all, somebody has asked if FERC is required to employ federal agencies as cooperators in writing an EIS. And it looks like somebody might have been typing, so we can give a second for that, but we are coming up on the end of our time.
Sure, and I can give just a really quick answer, and anybody else feel free to jump in if I'm incorrect in this, but I believe when it comes to cooperating agencies, there actually is, there are regs out there that define who must be a cooperating agency and who isn't. It's actually very specific. I think we actually drafted a comment arguing that the Delaware River Basin Commission was needed to be considered a cooperating agency for a project. I forget on which docket we did that. But there are, it jogs my memory that there are specific regs on that issue.
And I'll add a quick one to that. We similarly had the same issues in that the review entities for Trans-Pecos were being provided by the owner-operator of the pipeline. We made the argument that they needed to be independent, and we lost on that matter.
Okay. All right, thank you guys. It looks like no one is typing and we're not getting any more questions right now at this point, and we are a little bit over time already. So I just want to say thank you to all of our wonderful presenters for the very interesting presentations tonight, and we hope that you can all join us in April for the next one and learn more about climate change and the exciting ongoing battles around that. So thank you guys. Good night.
Thank you.